So I'd like to begin by acknowledging the traditional owners of the land on which we meet today, the Wurundjeri Woiwurrung peoples, and pay my respects to their elders, past and present. We're very fortunate today to have with us a visiting scholar from China, Professor Li, who's based at the Guangdong University of Technology. Before that, Professor Law was a member of the academic staff at Renmin University and also the China University of Political Science and Law. I should note that Professor Law is a distinguished professor of law at the Guangdong University of Technology Law School and has published widely on intellectual property law with a particular interest on the intersection between intellectual property law and technology. Professor Law has been a frequent visitor to law schools, foreign law schools, including New York University, the Max Planck Institute for Innovation and Competition, and Victoria University of Wellington. So today's discussion concerns an area that everyone is talking about at the moment, namely artificial intelligence. A lot of scholars, researchers are looking at issues that arise as a result of artificial intelligence. I certainly am in the context of financial regulation, for example, and financial services. In Professor Law's case, the topic concerns the question of whether intellectual property rights protection, whether as a matter of copyright law or patent law, extends to works created by artificial intelligence. And that's a question that's being debated, I understand, in all jurisdictions. It involves a fundamental question about where human creativity and invention begins and where it ends. And I think that's partly because under the copyright laws in most jurisdictions, copyright is only available to protect human creativity. And so Professor Law will discuss how this question has been treated by Chinese courts to date, and will outline a number of recent cases. And I expect that includes one case that I heard about that was decided at the end of last year, in which a court in Beijing recognised copyright protection for images generated by AI. But the question remains, is work created by AI capable of being protected by copyright? And if so, an interesting question is, well, who owns the copyright? So Professor Law, I expect, will speak for perhaps 30 or 40 minutes. And then perhaps there'll be time for a few questions after that.
Yeah.
But thanks very much again for visiting and for offering to deliver today's seminar. Over to you. If I could ask all of you to put your hands together to welcome Professor Law.
Thank you. Thank you, Andrew, for the nice introduction, and thank you, Sarah, for invitation. And also, thank you for Professor Chen to come here in person. Thank you all for coming here for my lecture in person. And I would be very appreciated for any questions or comments or criticism. Also, Ben, I guess you probably know AI much better than I do. AI is definitely a very hot topic. It's hot in every area. But copyright law is definitely one of the hottest area, well, AI concerns. Why is that? So, as we all know, when internet started to be popular, some people say copyright is dead. And the reason is because information technology rooted, based on copy, the way it works is to make copies all the time, everywhere. So why AI is so challenging to copyright law? Let's take a look. First, I give you some example. First, let's take a look of some examples of AI-generated content. This is a poem. I don't know if you read Chinese, but from the form you can see it's a poem. It's a poem from a poem collection from Microsoft Robot, which is published in 2017. And this one is a picture I downloaded from OpenAI. And this one, you can read the instruction. It's actually also downloaded from OpenAI. It's a video generated by AI. So let me ask the question. If you don't know how these three works are created, what would your answer? Are they copyrightable or not? I guess the answer would be definitely yes, because they are much better than what I can do. But when AI comes in, then people are not sure. So why? That's the topic what I want to share with you. So in this lecture, I would divide my presentation into 4 parts. First, I would like to give you a very basic of copyright law, what can be copyrighted. And second, what is AI? Because only when we know what AI is, we probably can answer the question better. And then I will introduce some newest AI-related copyright cases in China. And then at the end, I will share my views with you, the conclusion. So copyright, as we all know, copyrightable materials must be expressions. We know a lot of copyrightable works like music, like drawings, like movies, like computer programs. They are all expressions, which means they have to use some signals perceivable by human being to convey some information. That's the first requirement. And the second one is they must be original. Again, yeah. So the materials must be original. Original actually has 2 meanings. First, it must be originated from the author. And second, it must demonstrate minimal creativity. It cannot be cliche, cannot be banal, cannot be like everybody can say, everybody can do, like just a straight line. It's not copyrightable. And the third requirement is it must be created by human. It must be created by human. It's a little bit strange, this requirement. The reason I say so is not all the copyright laws set explicitly this requirement. At least in Chinese law, there's no provisions. At least, I don't know in Australian law, I didn't check it, but I know in the United States, actually in the Copyright Act, there's no specific provisions require works have to be created by human in order to enjoy copyright protection. But in some countries, like in German, it does require the work must be created by human. As we can see here from the section 2, number 2, it says only the author's personal intellectual creation constitutes works within the meaning of this art. And in China, although we recognize works, so-called, although individuals, both individuals and legal persons can be authors, not only copyright owner, but we can be authors in China. Legal persons can be authors. But it's widely recognized that works can only be created by human because legal persons, they can't create anything by themselves. They have to create it by their employees. And the photo here I show is a famous case, which happened in the United States. The monkey, whose name is Naruto. I mean, through this case, it has a name. So it took a selfie accidentally. It just to pick up the phone of the journalist whose name is Slater and took a selfie. I mean, if it's a normal selfie, it's a normal picture, maybe we won't pay any attention to it. But because the journalists say it's a selfie of the monkey, so it's attracted a lot of attention. And the PETA, the so-called animal welfare organization, brought a case in the United States against the Slater, claim they should enjoy the copyright of this photo for Naruto. So the judge rejected the claim. Although US copyright law doesn't require explicitly that works have to be created by human, but the wording actually implies that only authors have to be individual, have to be natural person, because the wording of the United States copyright law says the heir of the author, the children, the widow of the author. Only we human beings will get married, we will have heritage. So these are the requirements for materials to be copyrightable. And what is AI? AI, I think everybody has their own understanding. Here I just give you some examples. UNESCO definition of AI. It says that AI have the capacity to process the data and information in a way that resembles intelligent behavior, just like we human being. And the EU had a much more clearer, more definite definition, because it's a law. It has to be enforced in its member states. So EU says AI system means a machine-based system that is designed to operate with varying levels of autonomy, and that may exhibit adaptiveness after deployment, which means why AI poses such big challenge to copyright law, because AI, just as Andrew said, it operates like a human brain. So in the AIGC, human brain, human effort, eliminated maybe, not shown much in the AIGC. So that's the reason people are asking if AIGC is copyrightable, if there's no human effort there, because AI can do everything we human can do. But is it true? IBM said, maybe not. Because IBM says AI, they put them into two categories. One is so-called weak AI. The other is called strong AI. Strong AI is just like human. We can think of a question and we initiate a task, and then we will think of the way to fulfill it. But now the AI we have is weak AI, which means they only can perform a certain task. They cannot raise the question. They cannot set the goal. Only we human will raise the question. We human will set the task. Which one you believe? It will decide your answer to the question if AI is copyrightable or not. Okay, with this in mind, we go through some latest cases in China. The first case in China in which AI is involved is so-called Feilin versus Baidu, which happened in 2018. So Feilin is actually the Chinese pronunciation for film. It's a law firm specialized in film industry, in entertainment law. So it's published an article analyzing the legal issues of cases in film industry. And the next day, it found an almost identical article is posted on another platform. So it should be a copyright infringement if there's no AI. But the defendant argues that the article is generated by AI, so it's not copyrightable. The plaintiff, however, argued that the article is original and it's described the way how this article is produced. As we can see, it actually has several steps to search the judgment and to manually review the cases, the judgment, and remove the irrelated cases. And then they will use the so-called visualization function of a database. And they will draw conclusion, form a so-called article, of course, with some introduction and instruction. The court investigation shows that the database which the law firm used does have the function. You just put the data in, and the software will generate you a lot of graphics. And not only graphics, the software also will give you a very brief analysis. So like this year, the cases are doubled. The trend is always going up, so on and so forth. So just a very, I'm sorry. Here is a, I don't know if you can read it because it's too small for me, the letters. So you can see the difference between the plaintiff's article and the defendant's article. Basically, the defendant copied the main content of the plaintiff's article. And the main content of the article, I mean, maybe 50% of it is actually generated by AI. So that's the reason the defendant argued that it's not copyrightable. The court found it's not copyrightable, but not all of them. The court said the graphics are not copyrightable because the graphics are generated by software, and no matter who does this, so far we give the same numbers, we will receive the same graphics. And the analysis which I just mentioned, the software will generate a brief analysis. That is not copyrightable because the court said, although it looks original, but it's not created by human. So human creation is a condition for copyright protection. That's the reason the court said the graphics and the report, both of them are not copyrightable. But the article as a whole is copyrightable. So after this case, lots of reports, because AI is a hot issue, lots of reports on this case with the title, AIGC is not copyrightable. Is that true? Soon, not long after, Tencent case happened in Shenzhen, gives a different answer. And the reports all say AIGC is copyrightable. So let's see what happens here in Tencent case.
The AIGC, is that AI generated
Content.
content?
Yeah, sorry, AI generated content. So in the Tencent case, Tencent, as we know, is a big giant technology in China. It has lots of subsidiaries. One of the subsidiaries published, which is the plaintiff, published an article on its website using the AI tool, which is called Dreamwriter, developed by another Tencent subsidiaries. And the article is very simple. It has 9 paragraphs. Each paragraph gives very brief information of the market information in the financial market information on that day. So when Tencent found the defendant copied its article. Of course, Tencent brought the claim, brought the case before the court. I don't know if you know that Tencent based in Shenzhen, and it is said that Tencent is unbeatable in Shenzhen in court. And this case is no exception. So the court found the article is original. Is it? I mean, if you don't know it's AI generated, then of course, given the size of the article, because the copyright law only requires very low standard of originality. So even it's a little bit different, it can be copyrightable. So the court said it's original. The question is, if it's generated by dream writer, or the operator does have some effort, human effort. And the court decided that it's not only dream writer, but the operator, they feed lots of information to the dream writer, including the content, including the writing skills, the article styles. So the only difference, the court said, this article, the process of creating this article is different than normal process of writing article is. The process is much longer. The operator, they did lots of things before, like what I just said, the material they have to choose to feed the dream writer, the style they have to set, the skills they have to define. And at the moment when they want an article to be generated, they just input some keywords. So the process is a little bit different, but the process does show that the operator has their, or demonstrate their sufficient so-called individual selection, judgment, and skill. So copyright infringement is found in this case. The third case is the case you heard, right? The case which is called the first case, which recognized copyright protection for AI-generated image. The interesting thing is the court, which says the AI-generated image is copyrightable, is the same court which said AIGC is not copyrightable. Namely, the court which adjudicated film failing case. So does the court change its position? Let's have a closer look. Here
Do you want to move to the next slide?
Yeah, I will. Thank you. Yeah. So in this case, Mr. Lee created a image, this one. It has a very beautiful name. It says, the spring breeze brought us tenderness. So as we can see here, a very beautiful
Need to move forward.
maiden. Oh, sorry. So we can see that this is a very beautiful, a picture of a very beautiful girl. So the defendant used the picture. The plaintiff was actually not sure. He was not sure if he can, if his image is copyrightable. So he claims that his picture is a work of fine art, but he was not sure. He said, if it is not, then it's at least comparable to the copyright works which listed in Chinese copyright law. So it should be copyrighted. The thing is, the difference is, in this case, Mr. Lee didn't even draw a line. Everything is drawn actually by the AI. It's not like the articles at least we put some numbers and we will modify the expression, the language a little bit. But here, he doesn't do anything. He just put some words What kind of words he put? Let's take a look. Lots of prompts, as you can see. It's not simple. You don't have to read carefully one by one. You just have to know it's only in one step. The plaintiff used so many prompts, and then he has to modify, has to change the prompts and the parameters in order to get the final image. And these are the pictures in between. So the court said, as we can see, even though the plaintiff didn't even draw a line, but he does put lots of effort, intellectual effort in it. And it does show the plaintiff's selection, his judgment, his skills, his arrangement. So the court said copyrightable. And the last case, the latest case happened in Guangdong. It's a little bit different case. It doesn't argue about if AIGC is copyrightable. It's actually the first case which decides what kind of liability the AI service provider has to bear. So in this case, the plaintiff is the copyright licensee of Ultraman in China. And it found that users, subscribers of a website can generate Ultraman images. You know Ultraman? Well, boys should know.
Ultraman.
Yeah, as you can see, the pictures here. Okay. So the thing is, if you type Ultraman in the dialog box, you get nothing. The AI will tell you, the website will tell you wrong message. And if you type Tiga, anybody know Tiga means? Because I just searched that there are like 47 official Ultraman, and Tiga is one of the maybe most famous name of a Ultraman. So if you type Tiga, then you can get a Ultraman. So if you type Tiga in jazz, you get a Tiga in jazz. If you type Tiga in with long hair, you got a Tiga in long hair. So the court said, well, copyrightable or not copyrightable is not the issue here. Definitely, as you see, the image there I just showed you, they are substantially similar to the original one, to the ones the plaintiff enjoyed copyright. The question here is what kind of liability the AI provider should have. And according to Chinese law, the court said the defendant failed to fill the so-called reasonable obligation, namely that's lack of complaint and reporting mechanism, the website, lack of potential risk warning, and lack of prominent identification, saying that these images, they are created by AI. That's required by Chinese law so far. So what's interesting about this case is actually some commentators argue this case, the court of this case actually missed a very good opportunity to set a precedent, to set a standard, to set a precedent, to rule if the using of copyrighted materials to train AI is legal or not. Because the website as an AI service provider is liable. It is liable because in the first place, the third party which provides AI tools to this website committed copyright infringement, because the website itself doesn't offer the AI tools. It doesn't save any pictures of Ultraman. All the Ultraman pictures, images, they get the so-called, they have to call through an API intersection from a third party. So it's actually a little bit strange why the third party here is not put in. But
joined to the action.
Yeah, but I think it's because this question is really an important question we need to answer. It's actually a question, the US courts are deciding now. They are facing, they have to decide. And it will have a great impact on copyright law. So they probably just doesn't want to answer. And here come to my conclusion. So first, I do think AIGC is copyrightable, just as other materials created without AI. We don't need to differentiate AIGC or non-AIGC. So far, they also meet the requirements. They are expression, they are original. Why? Because in order to be original, there must be human effort. No human effort. The AIGC, they won't be original because everybody can use the AIGC to create the same material. And as we know, if everybody can create the same material, then they are not original because they are not different than others. So it's not AIGC copyrightable or not. It's if the AIGC is original or not. And the second, give AIGC copyright protection will not diminish the justification of copyright law. Lots of people argue that there are several justifications of copyright law, as we all know. We can basically divide it into 4 categories. Some people see we have to protect works, give them copyright protection because the authors, they invest the labor, intellectual labor to create the works because they sort of demonstrate their personality into the works. The works are like their children, their spiritual children. So we need to protect them. Or some people say that the reason why we have to protect copyrighted works, because in that way, we give the incentives to the authors. Another view is in order to, in protecting copyrighted works, we actually promote a fair competition. So people will be honest, will create their own works, and we will promote the welfare of the culture of the, we will, just promote a fair and better culture. But by giving AIGC copyright protection will not diminish this justification. Because some people say human being just invest very little or almost no efforts, so they don't deserve copyright protection. But remember, we have the requirement of originality. So if their investment, their intellectual investment is so little that you can't see even, you can't even perceive any intellectual effort from human being, then such AIGC cannot satisfy the requirement of originality. So they will be excluded from the copyright protection. And I argue there's no need to limit the copyright protection to human creation only. remember we said at the beginning, we said, although in some countries, the copyright law don't specifically prescribe that only human creation can enjoy copyright. It's not necessary because it's impossible to differentiate AIGC or non-AIGC if the one who created the material, they don't tell you. It's no way you can differentiate them. And it's no need to differentiate them. As I just said, if the AIGC is not original enough, they will be excluded from the copyright protection. So in that case, in that sense, only human creation can be created. In fact, even the law doesn't require only human creation can be copyrighted. In fact, only human creation can be protected. And if we put in the law that only human creation can be protected, then we probably would make ourselves awkward. Just like in the case of Zaya Dadong, a lady registered a work with US Copyright Office. And because the work looks very original, US Copyright Office issued a certificate for her, it's copyrighted work. But later the Copyright Office found out that AI is involved in in that work. So US copyright law withdrew that certificate and issued a new certificate indicating that AI is involved in this this work. I mean, if we put it in the law that only human creation can be protected, then we probably more often we will find our in such awkward situation. And the third, I would argue that using copyrighted materials to train AI can be fair use. So far, the materials, so far, the materials are legally accessible. They don't get the material by illegal way. So far, they will delete the materials after they trained the AI, because training AI actually constitutes a transformative use. They won't be a substitute of the original work. Again, now I'm very open. I'm open to questions and comments.
Well, thank you.
Thank you.
Let's just thank you first for the really interesting presentation. I'm sure there are a few questions that we have. One that came to my mind is whether the purpose of copyright is less to recognise creativity, but more to identify who should be entitled to protection, who should be able to claim protection under copyright. And so if you had something that was generated purely by AI, then without any human involvement, then presumably you wouldn't have a human author. Mm-hmm. And so the author would be the algorithm or the technology itself. Mm-hmm. But can the technology itself be an author and therefore claim protection? And if in that situation, who is the owner of the copyright? Who can claim protection if it's generated purely by AI and not by any human? I would argue that in that case, the works or the materials generated by AI is not copyrightable, so that everybody can use it. Right. So you don't need to attribute the work to any author. Right. So copyright would only extend to somebody, a human person who could claim some degree of authorship in respect of the AI generated content. Yeah. In other words, you need to have a human in the picture somewhere, because otherwise
Yeah.
there'd be no one to claim protection or
Yeah.
to claim that it's copyright.
I mean, even you or some people claimed ownership to a so-called purely AI generated content. Then remember, copyright protection is a so-called weak protection, which means it does not exclude other people from creating similar or even same works, and therefore excluding them from copyright protection for same works. So if lots of people enjoy copyright for the same work, then it makes no sense.
Understood.
Yeah.
Ben.
Just a comment that might jump on the back of Andrew's question there. So in the Australian context, you might be interested to know in the there was a patent case run from the IP, the Patent Office, against Stephen Thaler, who's been involved in litigation throughout the world, represented by Dr. Ryan Abbott, who was here a couple of years ago, and I interviewed him. And at first, so that involved, Stephen Thaler came up with a machine called Davis, I think is the device for the automated bootstrapping of unified sentience. And he claimed that it autonomously generated two inventions. Our most advanced technology experts say the purely autonomous artificially generated content is not really happening yet. There's got to be some human prompting. But nevertheless, the court basically accepted that claim for the purpose of determining whether or not these two inventions came up with the claim that it had for the purpose of determining whether or not these purely AI generated inventions could be patented. And the person in this court said yes. Based in the Court of Australia, simple, if human beings and their invents and their inventions can be protected, why can't human beings' inventions, which also invent, why can't the inventions of the inventions be protected? That was overturned by the Full Federal Court, and the basis was that there was the patent law did not allow a non-human inventor to claim inventorship. They weren't entitled to the ground of patent validity it was like the top. And one argument that's been trying to make this relevant to your question is, well, it's just like the owner of a cow. It probably will put the part of the owner of an apple tree, the apples. So we just apply that here. So here, the owner is the owner of the maker of the position. And his child's progeny and inventions should be used on the project.
Very interesting. And was that primarily on statutory interpretation grounds, or?
It went in a really odd way. It came up under, it was, so there are two words, at least one was filed for patent Australia, one of these it's on the patent operation agreement, as Australia, as a lot of other countries. So there are specific rules applying to patent process coming through this team international process. One of those regulations says identify the inventor. And so speak with the inventor's name as Davis device and
Right, interesting. Professor Law?
Yeah, I think that doesn't make sense. I mean, we don't need to how to say that, to specify who's the real owner, who's the real inventor. I know that case. I mean, that's what's that person, Dr.
Thaler.
Dr. Thaler. He failed in many countries, in the United States, in UK, and in Australia is different. Now, first he succeeded and then he failed, but he did register his patent in South Africa. I mean, at least in copyright law, the authors has the right to, to sign his real name or fake the name or pen name or remain unnamed. So why we should find out who the real author is, and it's actually impossible. Even patents in patent law, it doesn't make sense to me.
Some really interesting questions here. Yes.
Thank you. I have a quick comment and two questions. I think when purely AI generated content should be owned by the monkey. And the two questions, you said Tencent cannot be defeated in court. One thing that China has done really well compared to the West is not let the large corporations influence the government bodies. So China, it did not happen. It did not used to happen in China. Are you saying that that process has started?
Say that again, please.
So Tencent cannot be defeated in court. And that was a statement.
It's just a saying, a so-called legend.
Yeah,
It has a very strong legal team.
right. Oh, okay, I understand. So my question then is that do you think the Tencent not being able to be defeated in court means the corporations are able to influence the government bodies in China as they do in the West?
So big companies able to influence the way in which the authorities might formulate policies or even how the courts might interpret the law.
I should say,
How influential are
I should
companies
say
like
yes,
this?
right? I should say yes.
Question to audience,
Yeah.
if you like. Anybody else?
Well, I think the real issue in relation to Tencent is what we call local protection. So Tencent is located in Shenzhen, the major tax contributor.
Yeah.
And the government will then protect its own local enterprises.
I understand.
So that's how it basically works out. That Tencent no lose a case in court.
I understand.
And also the other, of course, is the lack of judicial independence in this case.
Is there a judicial independence?
Yeah.
Okay, interesting. My perception was China is a lot better than the West in this department. All right.
Oh, no, no. No.
And you have
Just very quickly, I'm interested in thoughts on whether or not the recent introduction of the intellectual property division of the Supreme People's Court will have a militating effect on Tencent's ability to always win IP cases down in Shenzhen or other, analogous cases.
Yes. So one question might be, are you seeing the emergence of a relatively independent body of principle law in this area in IP rights? Did you have anything further you wanted to ask?
Once you finish.
Sure. So that might be an interesting question, whether we're seeing an emergence of jurisprudence as a result of the specialist court division, or whether in fact it is quite ad hoc in nature, the development of the law in terms of interpreting the law and applying the law. Do you see that there is a body of law developing in this area that might stand alone and guide the courts in the future?
Hopefully, it's a quite complicated issue. It not it doesn't have to do with the development of IP, of the technology, IP protection in China, but also has something to do with the staff, with the people. Then especially nowadays, there are so many patent cases. There are so many cases which normal, in China, the jurists, the judges, the lawyers, they are normally like me. We only have a background of law. We don't have background of technology. So with the IP courts, IP division, then more and more people, more and more judges will have the technology background, and they also have so-called technology officer of technology investigator involved in. So IP court, IP divisions do have a more independence than other courts. And remember, in China, IP cases, cases and judgments are the first and are the most to be published in China.
Very interesting. So we're almost at the end of time. So perhaps we just have space for just one more question. Did anyone have a question they wanted to ask? If not, then we can ask you to follow up with your question if you had one.
Yes, I know. Anybody else doesn't have one? So, all right, thank you. Thank you to give me the opportunity. So my perception is, after listening to your presentation, that the court changed its view and started awarding rights in machine-generated content, while previously it did not. So the question is, did that change in view happen after the Tencent case?
They changed the view after Tencent case. I think they probably, well, people said that they changed their reasoning, the way they reason the case, because in the failing case, they just analyze if there's a human effort, if human, they say only human created works are protected. But in Tencent case and later in the Mr. Lee's case, it's the judges actually take much effort to analyze if that intellectual labor is invested. If they focus more on the works on the AIGC itself, but not the who's behind that AIGC, but the AIGC itself, if it's original, if it demonstrates different selection or arrangement of the order. So I think that would be the way of reasoning in the future.
No doubt the future will tell us a lot more about how the law is developing in this area, not only in China, but in other jurisdictions as well. So thank you, Professor Law, for a really interesting and informative presentation. That brings the seminar to a close. I'd like to end just by thanking Catherine Taylor, the Asian Law Centre, for organising the seminar, and to thank all of you for attending. But if we could put our hands together once more to thank Professor Law.
Thank you.